Your Honor, this is Jason Walterman, 24 CF 1518. You asked to put him on towards the end of today's
Yeah, I
docket.
just didn't want to do the Ferretta hearing because it takes a while and leave everyone else waiting.
Yes, Your Honor.
All right, Mr. Walterman, what are you asking the court to do?
Dismiss these charges.
Well, that's not what we're here for. No, that's not going to happen. I don't get to dismiss charges unless a motion is filed.
Yes, I filed a motion to suppress and a motion to dismiss. I guess it's not reached again, the mail from the jail.
Y'all seen anything?
This will be the second time I've submitted it.
Well,
Right.
the issue is, Mr. Walterman, is that you're represented by counsel. And so
Yes.
when you file things, when you're represented by counsel, unless they're adopted by your lawyer as motions they want to pursue, then they're a nullity. It's like they never happen. They get struck. So other than dismissing the case, what are you asking for?
You reviewed discovery, see it's been amended several times due to the unlawful traffic stop. Everything that's supposed or alleged evidence is inadmissible in court. The charges are completely fraudulent. I did not possess a gallon of methamphetamines nor a gram of fentanyl at all. It was a targeted,
Mr. Walterman,
yes, sir.
earlier you said you wanted to talk to me about either representing yourself or getting a different lawyer. So that's what I brought you back to talk about.
Yes, sir. Yes, asked counsel to put these motions in with the case law, and I did all the work and told her about it. She didn't submit it, so here I am. I guess I need to represent myself. I don't want to be another statistic.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God.
All right. State your full name and date of birth.
Jason Michael Walterman, 79, I'm 45 years old.
And so, Mr. Walterman, do you understand that lawyers have an ethical obligation not to pursue motions that they don't think that they can't in good faith think they're going to win? You understand that?
I realize that it's working against me, that's for sure.
That's not what my question was. My question is, do you understand if you ask your attorney to file a motion that he or she says, I don't think I've got a good faith basis to file, they're not going to file one because it would be unethical for them to do so?
I guess that's why we're here today,
Okay.
needing to relieve my
But
counsel.
again, my question is, do you understand that?
Do I understand that it's, that she didn't want to put the motion in for me?
I asked you a question. I asked if you understood it. That usually involves a yes or no answer.
Yes.
Okay, so you do understand that. So you've asked to file, or you've actually filed your own motions, but since you're represented, they're a nullity. Okay?
I must submit those?
Unless you're representing yourself. But I have to go through what's called a Ferretta inquiry to find out if I think you're able to represent yourself. So, again, what are you asking for today?
I would like to represent myself.
Okay.
Do not
Why?
believe that the council has my best interest at heart or...
All right, so the issue, do you want to represent yourself, or you just have an issue with your current counsel?
You know, I realize the state's attorney's office is running the whole program between the sheriff's department, the public defender's office, even the outreach or conflict counsel. And, you know, as much corruption as I've seen them operating at, I don't feel safe with any of them handling my life. Manufacturing charges, tampering with evidence, falsifying police reports and certified documentation, targeting individuals, me especially, defamating my character publicly, personally.
Why do you think you're being targeted?
That I have not figured out yet.
Right from the start, this defendant walks in with absolute confidence, not the quiet kind, but the dangerous kind that ignores reality. He genuinely believes he understands this case better than trained attorneys, and that mindset is already setting him up for failure. Court is not about belief, it is about procedure and experience. He talks as if research alone can replace years of legal practice, as if preparation automatically equals mastery. But confidence without knowledge is a trap. The judge doesn't need to push hard at all. The flaws reveal themselves almost immediately. He speaks with certainty but not accuracy, and every sentence exposes the gap between what he thinks he knows and how the courtroom actually functions. This is how people talk themselves into worse outcomes, by mistaking boldness for competence, and the system does not reward that mistake.
I'm stuck with no resources. I don't have any law library, real.
Yeah, but you understand that you're currently in jail because you failed to appear for your
Yes, sir.
trial date.
I sure did.
All right, so are you trying to represent yourself?
Yes, sir.
That's what you want, okay. How far have you gone in school, Mr. Walterman?
Almost the 12th grade.
If I asked to verify information, I'm not trying to be offensive or anything like that, Mr. Walterman, but what you said was you didn't finish high school.
No, sir.
Did you get your GED?
No, sir.
And do you have a career field?
Professional construction worker, supervisor, superintendent.
Okay. And when's the last time that you've worked?
6 months ago, something like that. I've been in jail for about 5 months now.
Okay.
This has cost me 2 jobs already. My vehicle, my place to stay twice.
I'd appreciate if you would just stay on track with what I'm asking you, Mr. Walterman.
Yes, sir.
Have you ever represented yourself before?
No, sir. Not in a court of law.
Okay. Even in a traffic ticket or anything like that?
I don't believe I've been to no traffic court.
Okay. Do you understand that you have a right to a lawyer?
Yes, sir.
And you understand that one has been appointed to you already?
Yes, sir.
But due to your concerns about what you said with the corruption, you'd like to represent yourself, is that right?
Yes, sir.
Even though the state of Florida pays for the lawyer for you?
Yes, sir.
Okay. And do you understand the advantages of having a lawyer?
No, sir.
Okay. So, say again?
I said, no, sir, I haven't received any advantages.
Okay. So a lawyer's legal knowledge and experience may favorably affect things like bail and pretrial release possibilities, may result in obtaining information about the case through skillful use of discovery devices, may uncover potential violations of constitutional rights, and take effective measures to address them, may ensure compliance with speedy trial and statute of limitations provisions, and may identify and secure favorable evidence to be introduced later at trial on your behalf. Do you understand all those things?
Yes, sir.
Okay, but you don't want to have a lawyer do that for you?
Constitutional civil rights have been violated to a serious degree already. I think I got my best interest at heart. If I had the law resources, I could skillfully and professionally present the actual facts of the case, and that should be enough to abolish my charges and set me free.
This is where the danger of self-representation becomes obvious. Good intentions do not equal capability in a felony courtroom. The stakes here are not small or symbolic. One wrong move can follow someone for the rest of their life. He believes effort alone can overcome experience, but court is not a place that forgives trial and error. Every rule matters. Every objection matters. Every pause matters. What he sees is confidence. The court sees is risk. The judge is watching closely now because the consequences are too serious to ignore. Preparation on paper is not preparation in practice, and the gap between the two is massive. This is how people walk themselves into disaster without realizing it until it's too late.
What I know about the Florida Evidence Code,
Yes, sir.
I can't say that I know anything about it.
Okay.
I haven't had access to any of my evidence except for the discovery. And then the times that I discussed my discovery with my counsel, the discovery got re-amended again and again.
Okay, but how do you think it's been amended?
It says so right in the
I understand, but what changed?
the amount of people that was at the stop to begin with.
Why do you know, how do you know how many people were at the stop?
I was present.
Okay. So, because I'm reading in your motion that you filed to suppress evidence that you said there was 12 to 15 law enforcement officers on scene within 6 seconds of them pulling you over.
Yes, sir.
So
We were sitting still on a parking lot when they come into the parking lot with no lights.
I'm not asking you about the facts of your case, sir.
Yes,
I'm
sir.
just trying to make sure I understand your issues with discovery.
Yes.
If you know that there was 12 to 15 law enforcement officers there, what's the issue with them amending to make sure all of them are listed in discovery?
Well, they didn't present the evidence until I said something about it. There was just one account or two accounts of an officer on the scene where it took me saying something for them to add some more officers on there, which still there's only one account of video footage. When there's that many officers on the scene, there should be that many video accounts plus their vehicles. You know, they exist and they were there. That's part of the evidence that's not being presented. Also, the arrest report has Jason Walterman. My name is Jason Walterman. Spelled wrong. My description is wrong as well. And there's many discrepancies and false statements in that arrest report.
Mr. Sheik, do you know how many discovery exhibits the state has filed?
I believe there are the original discovery and then two amended, Your Honor.
Okay.
One was just adding more of the officers that were present on the scene, and then the other one was the FDLE report, Your Honor.
Watch how his focus shifts around the room instead of staying anchored to the process. He reads meaning into every look and movement, as if the courtroom itself is working against him. This is where perception starts to replace reality. He feels watched rather than guided, judged rather than evaluated, but none of that helps his case. While he scans faces, the judge is scanning facts. While he builds theories, the court is building a record. These two worlds do not overlap, and the disconnect keeps growing. He is telling a story only he believes, inside a system that demands proof.
So, Mr. Walterman, I'm looking at the discovery exhibits because you said they've added a bunch of officers.
No,
Hold on. From my reading of it, the only one they added on the amended discovery exhibit was a Deputy Langer. Everyone else was already listed, and if you read on the actual exhibit, it says, this amended discovery adds previously unlisted Deputy Sheriff Langer and recategorizes the deputy sheriffs who were previously disclosed in initial discovery dated 8/6/24. So it only added one person. It just recategorized people as they need to be under Florida Rule of Procedure 3.220. The second amended discovery added an FDLE chemist, who I'm assuming tested the substances to determine what they were. So there's only one new law enforcement officer that was added, and you made it sound like there was 12 to 15.
I'm asking where's their accounts of being on that scene? It only shows those few officers where there was a whole lot more. Like I said, before I could put the gear shifter in park, there was a splash of a targeted, coordinated event, not an everyday ordinary traffic stop as my counsel told me it was. My tag light was not out of place, nor was the tag. It was right on the bumper.
I'm not asking you anything about the facts of the case, sir. Mr. Walterman, have you ever seen a criminal trial? Have you ever seen jury selection?
No, sir.
Do you think it might be an advantage to have a lawyer who's participated in trials and jury selection to aid you through this process?
I couldn't afford an attorney that was in my interest.
You understand that at a trial you have the right to remain silent?
Yes, sir.
And do you understand at a trial you have a right to testify and tell your side of it?
Yes, sir.
Do you think it might be an advantage to have a lawyer to counsel you on as to which one would be better for you, and give you the pros and cons of those things?
Yes, sir.
Okay.
Had a lawyer, but I didn't receive any sureties or counsel of upholding nature.
I'm not sure what you're saying. You gotta just be a little louder, Mr.
I
Walter.
wasn't presented with any factual knowledge or, how to guide this case with counsel, other than she wanted me to commit perjury and be extorted for $1,000 to accept 2 felony drug charges that I didn't possess any drugs for to begin with.
She wanted you to commit perjury and be extorted.
Well, that's what admitting to guilt would have been committing a crime to say I'm guilty. That is perjury, isn't it?
Well, Mr. Walterman, most people who enter a plea in my courtroom end up pleading no contest, which means they're not admitting their guilt, and they're doing so because it's in their best interest. Not admitting their guilt at all.
But I am not guilty.
Oh, I understand. I'm just... And do you understand that a lawyer can call witnesses for you and make sure they come to court? I need an answer, Mr.
Yes,
Walter.
sir.
Okay. The microphone doesn't pick up nodding.
Yes, sir.
Do you feel that you could question witnesses who appear against you?
Yes, sir.
Okay. Have you ever cross-examined a witness before?
No, sir.
So based on my earlier questions about knowing the evidence code, wouldn't it be helpful to have someone who is familiar with the evidence code question the witnesses?
Would most certainly be helpful.
Okay. But you don't want that advantage?
Yes, just counsel would be just fine with me. I was stating I haven't received that.
Okay. But again, I've asked you if you had an issue with your lawyer, and you said you just want to represent yourself.
Well, my best interest wasn't being looked out for. That's why I was needing to.
How so?
I did the work, studied the case law that backed up the findings for my plea of not guilty for every account with extra backup on it. Gave her the motions or told her.
Case law for your plea of not guilty?
Well, that was backing up the case that I'm fighting right now for my freedom, and the charges that was put against me, stating what made those charges not of any merit or substance, and I wasn't getting nothing but this is the best I can do, plead guilty to something you're not guilty of. It was okay to target individuals in Florida to do this type of extortion or bullying or gang stalking. Or
Who's gang stalking? What does that mean?
it's where a group of individuals conjure or coordinate coincidence to attack a being, to take advantage of it.
You're saying someone's doing that to you?
Even when explanations are given clearly, they never fully land. He filters everything through his own assumptions. Facts become suggestions, rules become obstacles, and advice becomes opposition. This is not how court works. The law is not flexible to personal belief. It does not adjust to confidence, frustration, or suspicion. The judge is trying to keep things grounded, but each response drifts further away. Understanding requires listening, and listening requires letting go of ego, something he clearly struggles to do.
At this time, based on what I've heard, Mr. Walterman, I can't find that you're capable of representing yourselves in this case. In fact, I think an evaluation might be in order. Because I'm not sure you understand what's going on here.
I certainly understand what's going on.
Well, based on my readings of what you've written in your pleadings and your answers to my questions today and your allegations of gang stalking and corruption against you, but you've given no reason why that would happen or even really who's doing it, I've got concerns as to whether or not you can really handle this case on your own, number one, and whether or not you're even capable of entering a plea or going to trial.
So can you appoint me some just counsel? So, that's going to be
I have.
within the law.
You haven't told me anything that's wrong with your counsel. Other than just to say this kind of conclusory statement that they're unjust.
I'm not guilty of the charges, yet I was asked to plead guilty to 2 felony drug counts that I didn't
Were you
possess.
asked to plead plead guilty, or were you told what your plea offer was?
Just that was the best that she could do.
Okay. And sometimes the best that can be done
Break
is
the
not.
law and pay them $1,000 to just walk away.
Again, I just don't really think you understand how this process works, and your lawyer's trying to explain that to you. And at this point, I'm finding under a FREDA inquiry that you're not capable of representing yourself.
Okay.
Ms. Rivers?
Your Honor, the issue remains that he refuses to get the evaluation. I've tried twice for the evaluation. He refuses to get the evaluation.
Is that the one you tried to do internally?
Yes, Your Honor.
All right, then I'd like an order appointing
Yes, Your Honor.
a doctor to do that evaluation. And Mr. Walterman, I'm going to order you to take that evaluation. And if you refuse to do so, you'll be held until you agree to do it, because it's concerning that you're refusing to follow your attorney's advice in doing this. And now, from what I've heard, I've got the same concerns that you may not be competent to proceed. Anything else, Mr. Walterman?
Sir?
All right, I'm going to put it on October 29th at 9. I would like that order so I can sign it certainly this week, Ms. Rivers, and then they'll send someone out to talk to you at the jail.
All right.
It may be done by Zoom.
What about new counsel?
Again, you haven't told me anything other than a conclusory statement that she's unjust. So I'm not going to remove her from your case and add someone else until you show me that she's done something wrong.
Kind of hard to show you any evidence. Stuck at the county jail. I talked to her. They come and stole all my paperwork, destroyed all the stuff, my property, immediately after I talked to her the first time. And I finally got a rediscovery, and it showed that it's been re-amended after I spoke with her again and was telling her some of the facts of the case that would be presenting my innocence.
Discovery is amended all the time, Mr. Walterman.
Yes, that's right.
As they add an officer who they didn't initially know about, or adding someone who's new as far as an analyst who's looked at substances, or like the chemist that was added in your case. Those people weren't witnesses until they became witnesses during the course of the case. I can tell you, as I was a prosecutor and a defense lawyer before I took the bench. I've had cases where we've had 15 to 20 amended discovery exhibits, depending on what the case is. It's just part of the process.
What about a fair and just due process? We were supposed to go to a trial a long time ago, and they keep putting it off.
You've missed court twice and been failed to appear twice. That's why you haven't had a speedy trial. And you didn't appear for your docket day. And because of that, I issued a warrant for your arrest because you didn't show up. And that's why you're sitting in jail, because you're a flight risk at this point after 2 times missing court and have to be rearrested. Anything else, Mr. Walterman?
No, sir.
All right, thank you. October 29th, 9 o'clock.
The final moments say everything. He treats the courtroom like a stage, believing he is uncovering something hidden, when in reality nothing has changed. The system moves forward exactly as designed. His arguments do not shift the outcome. They only highlight his lack of preparation. Every correction pulls him deeper into trouble because procedure never bends for emotion. Experience always outweighs confidence here. The judge sees the pattern clearly. This is not defiance, it is misunderstanding. And misunderstanding is costly. Self-representation sounds empowering until reality proves otherwise. This moment becomes the lesson.